assessment that the company won't be insolvent. So just simply to say that there's a real, as opposed to remote risk of insolvency, is just far too low. It would hinder and stop business activity. As a director, you could never take a judgment call. You could never take any risk at all in terms of business risk, just in case you are unable to pay a creditor. It's far too low a test. So this will be big work for all of us, because directors are absolutely coming to us right now. I mean, we might be ahead of you in India in terms of here in Hong Kong, in terms of the timing of insolvencies, because we've been suffering from COVID-19 for possibly a few months longer, I say it. And so we already have many inquiries by directors asking what to do. Are they virgin insolvent? Are they insolvent? What do they need to do about the creditors? And then going back to cash flow, what measures can they take? So that is the landscape, if you like. The number one part of my talk, the government efforts to increase the cash flow situations, depending on what secondly, directors' duties in performing their obligations in this awful time in our economic history. So I hope that has been helpful and informative, and I of course will take any questions that people have. If I can answer them, I'll be delighted to try.
Hello.
Hello, I can hear you.
This is Ajanta Gupta. I want to ask, can you show some light on application of Gibbs rule in Hong Kong insolvency law?
Yes, I can. That's an extremely difficult, it's an extremely difficult question, and it shows the sophistication of the audience that I'm dealing with here. Just to step back a moment, the Gibbs rule was a rule determined in the 19th century in England, and essentially the rule says that a debt cannot be extinguished, cannot be cancelled by a foreign court. So in the original case of Gibbs in the 19th century, it was a case where a French court was trying to extinguish an English law governed loan. And the English court said, you French court can't do that. Everyone's going to change, amend, extinguish, or compromise an English law governed debt. It will be the English courts. And that is how many English common law countries deal with the situation, and Hong Kong is no different, so the Gibbs rule applies. Now, interestingly, there are some countries who say that is a very silly and old-fashioned rule. Singapore is a country like that, and the United States is a country like that. And they say, well, if you're a company and you're in dire straits financially, and you want to structure your debts, and you're an international company with many different loans governed by many different laws, if you turn up to the Singapore courts and seek a restructuring through a scheme of arrangement, and we happen to have to restructure, extinguish, or compromise foreign laws, why shouldn't we do that? This is the central interest of the company, and as a creditor will expect an international company to be seeking some relief in international courts, where those courts have the power to amend and compromise debt, even though the law is not the law of Singapore. So there is a great debate in the world as to whether Gibbs applies. I can confirm, although I'm not a Hong Kong lawyer, I keep pointing out I'm a BVI and Cayman lawyer. In Hong Kong, when we under Hong Kong law, and it lead to what's called forum shopping. So let's imagine there was an unethical company out there who simply chose to go to a country where foreign debt can be extinguished contrary to the Gibbs rule. They might look for courts that were more debtor friendly, that were more willing to erase debts that were owed. And banks, of course, are very suspicious of those sorts of moves. So it's a complex, very, very good question, a complex question. But Gibbs is still, the old-fashioned rule of Gibbs is still alive and well in Hong Kong. That's been reaffirmed time, with some minor exceptions to do with multinational schemes of arrangement, where the courts of New York in particular would have no problem with the variation of New York law debt in Hong Kong. It's quite a technical exception, which I've dealt with many times, but just to be complete so no one criticizes me for not giving them all the caveats and, and provisos there. So I hope that answered your excellent question.
Thank you.
Well, my pleasure. And there's another question I just have on screen here, another extremely difficult question. It says, this is from Ravi Rajagopalan. And Ravi says, can you contrast the UK insolvency law provisions relating to wrongful trading? So, for example, Section 214 of the 1986 Insolvency Act, as against the common law fiduciary duties of directors owed to creditors. For example, would the common law obligation still prevail even if Section 214 was suspended? Now, I must say that I am absolutely not an English lawyer anymore. I haven't practiced English law since 2008. I'm no expert, but having just read this very interesting case, as I said, of BTA Sakana, Lord Justice David Richards is actually very clear, because he does describe the interaction between the legislation, the 2006 Companies Act in England and the 1986 Insolvency Act in England. And he does actually say that the common law supplants and adds to that legislation, because the legislation expressly says in England that the common law still applies. So, for example, in this particular case of BTI and Sakana, there was no statutory test for when the director's duties applied to creditors, even though there were statutory duties set out in the legislation. So to try my best to answer the exact question of Ravi's here, wrongful trading under Section 214 is essentially continuing to trade when the company is insolvent. And so in those circumstances, that there are obviously English cases that indicate when a director should know that the company is likely to become insolvent, and when he or she should not trade. So the common law will add to and explain Section 214. And in fact, those fiduciary and duties in negligence will inform the lens of refraction, if you like, that one must look through, the spectacles one must put on one's nose to examine if the director could be guilty of that wrongful trading at the time. So I hope that answers the question. If Section 214 is suspended by the UK government, then I would. I'm a mere lawyer, so what would I know? But I would expect that all of the case law that attaches to it would also fall away and not be effective. I'm getting a very nice thank you from Ravi on the text message. Well, thank you very much. There's another very interesting observation from Krishna Bhattacharya, who says, very witty, to solve the cash flow problem, government could just print more money. But of course, this would lead to inflation. Do you think that inflation could be a possibility for economic revival for the time being? Wow, Krishna, that I must confess, even a talker like me has to be humble and say, that's beyond my expertise in terms of macroeconomics, and I open that up to the floor to greater intellects than mine to maybe comment on it. Okay, well, there don't appear to be any further questions. I just wanted again I'm really truly honoured to have participated in this. I hope I've given you some small benefits that will be useful to you in your careers. And Dr. Shikha, I wonder, should I hand back over to you?
Thank you, Anne. I assume that the audience has no questions now. No further questions. Then we can end this Friday webinar series. I really have to thank you for taking out your time. And we have students also. We have some very great friends of our course and institute here. Okay, there's one more question, Anne. There's one question in the dialog box.
Now Mann has come in with a final last-minute question, which is a very, very contentious one. I'll just read it out. I know people can see it on the screens, but it's helpful to read out for anyone who's on a phone. What are your thoughts on suspending insolvency provisions? Shouldn't insolvency law be used more proactively in these times to allow companies to restructure their debt by taking interim finance during these times, or debtor in possession financing possibly in the future, says Vijay Sakar. I think this is a problem. I really am concerned, and this is just my view, but I am concerned about the many countries who have adopted measures that essentially suspend the normal working effects of insolvency laws. So, for example, many countries, Australia and England, have suspended wrongful trading duties for directors, statutory demands instead of, I think in Australia, again, I'm no expert, statutory demands instead of being 21 days have been extended to 6 months. I think in Australia there are measures in England coming into force, I believe, that will make it extremely difficult for landlords to enforce the obligations due under the lease, and foreclosure, and certainly taking possession of the home will be essentially impossible under the moratorium. Now, let's suppose that there is a universal global moratorium essentially on all material significant global finance. That would be devastating, because there would be no efficiency in the economy, and failing businesses would be allowed to continue, and those failing businesses are businesses that will cause future economic harm to creditors, to innocent people who expect insolvency laws to protect them. And directors will not be under a personal liability to think as carefully as they did, because the application of wrongful trading will not be there. It will also, just talking about professionals, be terrible for us professionals, because it means that in times of economic crisis and insolvency, instead of relying upon nearly 300 years of developed insolvency law, restructuring, and all the rest of it, instead all of those laws will simply be paused, and we won't be called upon to advise or assist anymore, because everyone will say, well, haven't you heard of COVID-19? Why should I pay you? I'm just not paying. And everyone will do that, and there will be a cycle globally, economically, where no one pays anyone for anything. And if that subsists, and maybe I'm exaggerating, how do you ever change the business mindset to require businesses to respect contracts, to respect the law of obligations and the performance of obligations? It becomes law, actually. So I'm concerned about it. I really am. I can see where certain measures for deprived persons, particularly socioeconomically, be protected. The very poorest, for example, homes and children and that sort of thing. But I think we have to be careful with it. It's definitely balanced. I see another question from Dr. Shikha, and she says, well, listen, in that case, Ian, how do you motivate the directors, particularly the non-executive ones, to take up the challenge of leading the companies in these difficult times, to, like this, and not to take an exit route rather than facing difficult decisions? Well, I have to say, I mean, I've spent the last probably 3 weeks being in and out of our conference with various directors of companies with functions in China, and some of them are executive directors, some are what we call INEDs, independent non-executive directors, some are Westerners and some are Chinese, and they are all faced with the same difficulty, which is they are very, very concerned about the cessation of economic activity. If we don't have it in Hong Kong, we don't have lawful trading actually as a law under Hong Kong law, but of course it does apply under the BVI, Cayman, Bermuda laws. If those directors don't have the stick of personal liability, then of course I agree with you, that they're not going to be motivated in the same way. But before you even get there, my advice to the directors is always maybe going back to the adage that our mothers used to tell us, that a problem shared is a problem solved. And very often the directors who are powerful, experienced directors running great empires actually feel quite vulnerable and scared at the moment. And when they come to us, we hold their hand a little bit. We have a pastoral and welfare role to say to them, listen, you may be worried about your personal liabilities. That's one thing. Actually, most of them are more worried about their reputation, about the company, about their employees, and their employees' welfare and the future. And the only way to resolve that is by having open dialogue and communications with all of your creditors and stakeholders to solve the cash flow situation. I keep saying to them, they have to get aggressive about being communicative and sitting there and burying their head in the sand, hoping that COVID-19 will end soon and demand for their products will come back soon, so that the cash flow hole can be filled is not a good way to deal with it. I should say that a number of directors simply have never experienced this type of economic recession. So some of them were not particularly hard hit in the last recession in 2008, because in 2008 China was still booming actually, and so for some of them it's the first time that they've ever had to deal with these sorts of issues, so it's very new to them. I see that Jane Pauline has come in with a wonderful comment. Currently, she says India has not suspended wrongful trading provisions in its insolvency statute as a result of COVID, and it's only suspended provisions to initiate insolvency. Would the attempt of directors to obtain loans, consequently securitize assets to obtain financing, attract wrongful trading provisions when the suspension to initiate insolvency proceedings are lifted in India and the company is subject to insolvency? What a dilemma. What a predicament. I don't know is the answer. One would have thought that those duties would still exist for wrongful trading. Maybe you know better than me, Jane Pauline. Maybe you've given it more thought. I have to say I haven't given it much thought, because we haven't had the suspension of those duties either in our jurisdictions. But I would have thought that those duties still apply, even though pragmatically your creditors can't take enforcement action. Because don't forget, the filing of a petition, the serving of a stat demand, the liquidation of a company are enforcement steps. Intellectually, the company, if insolvent, is insolvent. And that is why you have this rule called the relation back rule. I don't know if it applies in India, but certainly in the jurisdictions where I operate, company is wound up. The courts say, yes, I wind up this company, I appoint a liquidator, but the effective date of this company being insolvent is the date when the petition was actually filed, and that might be 3 months prior. That's called the relation back period. And so all the insolvency laws about wrongful trading, unfair preferences, giving away assets at undervalue, all those sorts of things start as early as the presentation of the petition. I always say the petition is an enforcement. It's not an intellectual status. It's not an intellectual comment on the status of the insolvency of a company. So that's how I would look at it. But again, I must say, Jane Pauline, thank you for your question, but I certainly haven't given it much thought. It's an excellent question, one that you will have to grapple with in India. I look forward to the Supreme Court judgment in India, where Jane Pauline is the lead advocate there. So very, very, very interesting. You're most welcome.
So I see there are no further questions. Thank you again, Jan.
Thank you.
Had a wonderful session. I personally had a lot to learn, and I'm sure all our viewers, they echo the same feeling. Just for the viewers, the video will be available on our YouTube channel. You tune in and watch it anytime. And we also encourage you to write to us any further question that you may have, and we can always lead it back to the speaker. And we can have more engagements. Thank you, Urvashi. Urvashi is a senior research fellow with the center, and it is basically her initiative that we started this Friday series, and our wonderful students and guests who joined us today. Do join us next Friday. Thank you.
Thank you, yeah. Such a informative session. Bye-bye.
Thank you very much, everyone. Stay safe.
Yeah. Bye-bye.